So it's an overview. So if you go to the next slide.
Okay.
I'll just say next, Chris. So we've had various bits of legislation, but it all began in 1975. Well, equal pay in 70, and there were two very different strands. And the Equality Act of 2010 really sought to combine everything under one umbrella and also bring into that some of the important case law that had developed over those years. So next slide.
Oops, sorry.
Yeah, we're going to go quite quickly. So yeah, the Equal Pay Act is now in the equality of terms section. And the principle is that a woman must compare her pay with that of a man in the same employment employed on, they call it like work, which is like similar work rated as equivalent under a job evaluation study or work of equal value. I think one of the problems with this is that we used to have equal pay questionnaires that employees could serve. They were got rid of by the, who was that by? That was when there was a coalition, Tories and Liberals. And an employer didn't have to serve the answers, but if they didn't, the employment tribunal could put in an adverse inference that obviously the reason they hadn't done it was because they had something to hide. So that was, you know, that's a backward step really, because how do you really find out? Unless you're really lucky and something gets revealed in the public domain and you find out, it's guesswork. So next slide, Chris.
I just did it.
That is there. Oh yeah, so where there's no direct comparator, and a direct comparator is always best if you can find one, you may be able to use a hypothetical comparison. And once a woman is able to prove like work, then the burden of proof passes to the employer, who has to provide a genuine reason for the pay differential, which isn't tainted by direct sex discrimination. The problem with a lot of this is in practical terms, like what the employer says is, well, she's been here for ages and he came in at the market rate. But I mean, really, that's why particularly big companies should benchmark all the time and not have loyal existing employees, you know, who came in at a low level, you know, not getting as good a deal as new people in a more competitive market. So next slide. So, well, quite often when people turn up at the tribunal, I mean, that even if they're lay people, they are asked what type of discrimination it is. And the most powerful really is direct, and that involves treating someone less favourably. So because of their sex than others would be treated. So it's that less favourable. And this includes discrimination because of the sex of the person whom the work is associated, or where the work is perceived to be of a certain sex, because we've got those strands in there. So an example of direct sex would be where a woman with appropriate skills and qualifications is not appointed to a position because she's a woman. This is so regardless of whether a natural man with similar or lesser qualifications had applied and been appointed, although it's harder to use a hypothetical comparator. Next slide. And discrimination by association is where someone is discriminated against because of the person they're associated with. The sort of most common ones are actually disability, where, you know, women caring for a disabled child have been harassed, and they're able to sort of take on the disability of their child. An example of sex discrimination by association would be a married couple who both worked for the same employer, but both dismissed upon announcing that the wife was pregnant. The wife could claim for pregnancy discrimination and maternity discrimination. The husband could claim for sex discrimination by association. And that's the case for that one. Next slide. Sex discrimination by perception. And that's where someone assumes they're of a certain sex. And an example would be if a doctor's surgery is looking to recruit a new GP and would prefer that new GP to be female, so that they had one male and one female doctor. An experienced female GP, Dr. Pat Davidson, applies, but is not invited because the person mistakenly assumes that she is male. So that would be sex discrimination by perception. Next slide. So probably a more common one is where indirect sex discrimination is where a provision, criterion, or practice applied to both sexes puts or would put one sex at a disadvantage. And then the thing with indirect is that an employer can objectively justify it, and that's where they can demonstrate that it was a proportional means of achieving a legitimate aim. Next slide. And so an example would be where an employer refuses to allow a woman to work part-time or to change her working pattern. And this may be grounds because it's established statistically that more women than men have childcare responsibilities and therefore are disadvantaged by a requirement to work full-time. And in such cases, the employer would need to show they could objectively justify the requirement for the employee to work full-time. Next slide. So the next strand is victimisation. So victimisation is where a person is treated detrimentally because they've made or intend to make a complaint or allegation of sex discrimination at work. Also where they give or intend to give evidence in relation to a complaint, and these are called protected acts. Next slide. So an example, this is one really in a grocery shop. Worker resigns after making a sexual harassment complaint, and then several weeks later she tries to make a purchase but is refused service. Quite often victimisation can be where an employer refuses to give a reference where they would normally give a basic reference. So, so next slide. So 3 things have to be proven: that there has been a protected act, the employer subjected the worker to a detriment, and the reason the employer subjected the worker to a detriment is because the worker has done the protected act. And this could be even if they're motivated by it unconsciously. With a lot of discrimination, it doesn't have to be intended. And I think that's really important. So next slide. And it also covers where people aren't actually doing it, but they're instructing, causing or inducing discrimination. Okay, next slide. And then there's harassment. So that's where one person harasses another and engages in unwanted conduct related to irrelevant protected characteristics. So that's age, disability, gender, reassignment, race, religion, sex, sexual orientation. And this conduct has the purpose or effect of violating these dignity and creating an intimidating, hostile, degrading, humiliating or offensive environment. I think the main point is the unwanted point, really. That's where you get lots of employers saying, oh, it was just banter, but where it's clearly not banter for the person, they've made it quite clear that they find it offensive. They'll have problems arguing that. So next slide. And sexual harassment is in the workplace is unwanted behaviour of a sexual nature, which has the same definition, purpose or effect of violating their dignity, making them feel intimidated, degraded or humiliated, creating a hostile or offensive atmosphere. And that can include where a worker is subjected to further unwanted conduct because of his or her rejection of or submission to previous harassment. It covers men and women. Obviously, it's rarer, but we've certainly had young Black men who've been sexually harassed by older white women. And clearly, I think it's a power issue. But it can cover verbal, non-verbal, physical conduct and can include unwelcome sexual advances, touching, sexual assault. I mean, we've had rape cases, so they border on, criminal, sexual jokes, displaying pornographic pictures, or sending emails with material of a sexual nature. Next slide. So, I mean, there are some exceptions where there's an occupational requirement where you might want to hire someone of a certain sex. And that's usually where there's some sort of privacy issues or religious requirements, or for a limited number of posts in the armed forces. It's quite rare, actually. Next slide. With pregnancy, it's not less favourably, it's unfavourably. So women have the right not to be treated unfavourably. And a woman must show that their pregnancy is the reason for the treatment. I have to say that the most common thing is where employers are really stuck on this 2-year service requirement to bring claims. and a woman says, you know, probably hasn't been there very long, says, I'm pregnant, and they think they can just dismiss because she can't do anything about it. The next slide. So, you know, with these cases, what invariably happens is that they will say something like this, that they're not performing properly. But really, we just have to show that it's only the telling, you know, the informing that things change. And there's a protected period, which is from the beginning of pregnancy until the end of maternity leave. And that's an automatic unfair dismissal and not subject to the reasonableness test. And that includes discriminating because of pregnancy-related sickness or because she's on maternity leave. I mean, that sort of thing is where there's been a promotion and someone hasn't been informed and given the opportunity. And an employer is also prohibited from victimising a job applicant or employee because they are or intend to become pregnant or because they intend to make a maternity discrimination complaint. Next slide. So discriminatory decisions in the protected period are brought under pregnancy and maternity claims, but ones that fall outside are more likely to then be sex discrimination. And you must identify in sex a real or hypothetical comparator, whereas for the others you don't have to. Next slide. So these are examples of unfavourable and less favourable treatment, detrimental treatments. That's dismissal due to informing employer of pregnancy, selection for redundancy or dismissal because of changes to her job during maternity leave, failure to inform and consult during maternity leave, refusal of training or promotion opportunities, reduction of pay or hours, pressure to resign, demotion on return to work. Next slide. And the thing about what's so interesting about discrimination cases is that there is an injury to feeling award, whereas there isn't for unfair dismissal. There's a basic award, which is the same calculation as the redundancy, statutory redundancy. And the other thing is they are uncapped discrimination claims. So the rules are that for unfair dismissal, it's a year at the gross salary of the person, or there is a statutory cap, which is about 89,000. But with something like this, there could be huge bonus losses, or there could be huge pension losses that can be included. And the lower band, less serious, is from 990 to 9,900, middle 900 to 29,600, and the upper band is 29,600 to 49,300. Unfortunately, indirect discrimination is usually quite low, but really it's how it's judged is really on the seriousness and how many times it happens and the length. So next slide. So I just sort of, flexible working does come into this because although it's no longer about caring responsibility and anyone who's been at a firm for 6 months can request flexible working. Can you do the next slide?
I'm sorry, yep.
There is, you know, it has to be dealt with properly so that the employer deals with an application within 3 months. And there must be an appeal process. Next slide. And these are the reasons that an employer can refuse. So quite often we see refusals based on this. Next slide. But when you're looking at flexible working, you do need to look at other rights. So it may be direct sex discrimination if an employer refuses a request from a woman when they've agreed to a similar request by a comparable man. And if an employer refuses to allow a woman to work part-time or change her working pattern, this may be grounds for bringing a claim for unlawful indirect. And that's again because statistically more women are the primary carers of children. And in such cases, the employer has to show that there was an objective justification for that employee to work full-time. So next slide. So, and where an employer might refuse a request and it's unfair, they may also face a claim for constructive unfair dismissal, and that's where an employee resigns in the face of a we call it a repudiatory breach, which is a fundamental breach of their contract. I mean, that's a breach so serious as to totally undermine the relationship of trust and confidence, which is intrinsic to the relationship. Next slide. So menopause, I mean, this is just listened to Radio 4 this morning, actually, and there was a whole programme on the menopause, much more talked about. It was a bit of a taboo subject even 2 or 3 years ago. Occurs for most women between the ages of 45 and 55. And, you know, there's been lots of surveys about how this affects women at work. And apparently almost 900,000 women in the UK alone left their job due to menopausal issues. And although it's not a protected characteristic, obviously if the symptoms are serious enough in that they are a physical or mental impairment, which is long-term, so has to be likely to last more than a year, which has a substantially adverse effect on day-to-day activities, then they'll be covered. So next slide. And of course, it could also be detrimental treatment because a woman is going through the menopause, and that can be related to sex or age discrimination. So to treat physical or mental health difficulties caused by the menopause less seriously or sympathetically than an equivalent ill male or younger female employee could be less favourable treatment. And if the symptom meets the definition of a disability, there would be the duty to make reasonable adjustments in the same way that you would for, you know, all sort of issues like this have that sort of test, unless it's something like MS or cancer, where you don't have to apply the test, you're automatically given the rights under the Equality Act around reasonable adjustments. So I think that's all the slides actually. So it was a real sort of quick sort of whistle tour really. Have you got a very good equality and diversity policy at your place?
I'm currently drafting our EDI policy. We have an EDI statement, and the Commission is very forward thinking and making sure we have an inclusive environment for our employees, commissioners, and also the clients we work with. So my next 9 months will be drafting that policy. What I think would be really fantastic is if you are running another one of these kind of webinars or workshops, I'll probably encourage other people to attend as well. Obviously, I don't know if you know much about the Commission, it's where we deal with appeals of justice. And obviously I work with many people under the umbrella term of lawyer. But when it comes to these kind of areas of the law, I think sometimes people can always learn a bit more. So I like to come to these things and see what we can take on as learning for ourselves, whether we can bring people in to do a short presentation. But no, that was fantastic just to go through.
Well,
I think
we can look at the case studies if you'd like to, because it's just a sort of practical application. Or, I mean, the other thing is, would you like our equal opportunities policy? Because my software is Practical Law Company, which the top 100 law firms use. It's been checked by lawyers and barristers. It's absolutely bulletproof, and you could just use that as your template and add.
that would be fantastic. Is there any cost associated?
No, I'll give it to you. No, because it's important that what you do is really accurate. And also, if you wanted to come back with any questions, I'm happy to do that, Sophie, because I think the thing is with policies, quite a lot of things, if they're not quite right, they can be problematic, but I think it's really good to have a really sound template. So I'm not sure if there's a long version and a short version, but I'll send you both if I've got them actually. But I think the long one is probably very good for training people in, because it will tell you what you should do. But I mean, I don't know about your organisation. Some organisations have duties to do more. They have to prevent. I think the schools and colleges might be one where they have to go that step further. But I'll have a look at what we've got and I'll send it to you. So that will be a good starting point from you. And like I say, I mean, all the top, London firms use it's owned by Reuters, and it's got a really, really good, it's probably got about 15 employment lawyers just checking and updating everything. So I know that whatever I give you is always up to date. We love it. We love it in the office because it just makes our life so easy.
That's fantastic.
So
Thank you very much.
there were just a couple of case studies. So these
Shall
are
I
just
get those up on screen?
yeah, that'd be good.
Okay. Don't be a minute.
Yeah, they're just really the most common scenarios that we come across. And I do have to say though that we've just sort of been looking at all our cases and monitoring, whereas pregnancy and maternity used to be our biggest type of discrimination cases because we do a lot of work for employees. It's now disability, but that's not because pregnancy and maternity is sort of reduced. It's just disabilities on the increase. Sorry, Sophie.
If you'd be willing to share, for your disability kind of claims, are you seeing more in terms of mental health or the physical?
Mental health. Employers not really understanding how terrible it is for people that suffer from anxiety and panic attacks. Quite a lot of unkindness, failure to make reasonable adjustments. I mean, that has been the huge rise, to be honest, and in all industries, I suppose, very, very senior people, and particularly around trying to force people back in the office. Because a lot of people have been really anxious about COVID because obviously they were frightened to death, and a lot of people perhaps had to screen elderly parents. And so, we see a lot of employers ignoring real concerns that employees have, and also ignoring the fact that it was perfectly fine when there was a lockdown. I think that's where employers are having a bit of a problem with flexible working requests, because if it worked well then, why doesn't it work now when everyone had to work at home? So the pregnancy one is this, I mean, believe it in this day and age that, someone can say that they're pregnant. I mean, I think this should really be about education, because the reality is that when someone goes off on maternity leave and you have to pay maternity pay, statutory maternity pay, I mean, that's 6 weeks at 90%, and then the rest is at the statutory level. You get it all back from the government. I think the one thing that is difficult is that those women accrue holiday. So they accrue, if they're off for a year, 28 days of holiday that has to be paid. And really, from a sort of organisational level, you really want them to be taking their holiday before they come back so that they get extra pay, because you don't want them to then have holiday from that previous year and then a new holiday year. Otherwise they'll just be coming back and then going off again fairly quickly. So that's the main issue. But there's a lot of misinformation, so employees not understanding that. And also, if you really want someone that's great, so what, they go off for a year, if they come back, they might be with you for like 12 years, and certainly when people work part-time, it is an opportunity to expand roles and bring new people in. And it may be that the maternity cover was brilliant and you can create another job for both of them, as long as you obviously keep that job open for the person returning. So this is someone that was dismissed after 4 months. Poor performance was given. She passed a probation period, because we still see people only doing 3 months. She had confided to someone that she's pregnant, and was told to keep quiet. But when because the company would do anything to save money, and then when she told the line manager that she couldn't have pre-booked holiday because she was going for a scan, it was after that she was dismissed. And she was terminated with immediate effect. I think she was paid in lieu. She pointed out she passed her probation period and line manager's comments had been good. And she accused him of dismissing her because of her pregnancy. And he just stupidly told her, when she told him this, that she couldn't do anything as she had less than 2 years service. This is actually a real case. These case studies are absolutely what happened on a previous case of ours. So she appealed her dismissal. And the sort of questions we've had is what potential legal issues arise. I mean, obviously, what we quite often do is a subject access request where there's accusations that someone has poorly performed. Because what we'd want to see is, written notes that, they weren't happy with their work, and communicating that to her. and asking her to improve. But if there's nothing, then an employer could really be in trouble. So how could the employer have dealt with the situation better is, well, obviously understanding that, you know, you can even discriminate against a job applicant. They don't even have to be employed to have rights if they're not shortlisted for a job because of a protected characteristic. But, you know, clearly if there really were performance issues, one would have expected that she wouldn't have passed a probation, that she would have, you know, managers would be talking to her and potentially putting her on some sort of performance review. And as with all, well, most discrimination, you've got 3 months minus a day to bring a claim. It's complicated now because we have to go to ACAS early conciliation. So we do that before the 3 months minus a day. And then if we're conciliating, it's open for a month and then we get another month to issue. So we've got an extension on that. But of course, we get people that come to us that are quite late. Is there any points there that you think?
No, I just think it would be to a manager to say there's nothing you can do to say it. It's just shocking, really, because yeah, it's I think most people, if I've ever spoken to them, they kind of believe what managers would say because of their position of power and how many people go through this alone.
Well, the thing is, yeah, you're right, because they might just take that and not look it up. But, you know, that's why things like citizens' advice bureaus and free access. I mean, there's an organisation called Maternity, is it Alliance?
Action, I think.
Maternity Action, that's it. They used to do a lot of stuff, but in fact, their funding really is a lot more around immigrants and healthcare. So we've always worked with them. I mean, if that's still going, it's got a really good employer helpline and an employee helpline. So, and then the second one.
Can you see that?
Yeah,
that's maternity. And this is the most common. It's where someone is trying to return to work and they're basically saying, actually, your job's disappeared. And the reason her job's disappeared is because really they've just sort of eroded it, you know, given bits of it, not probably got a proper maternity cover, and then decided, because she hasn't been there for a year, that actually they don't need her. And rather than, if there's excess or surplus of labour, looking at, well, who is there, not just her, and looking at a pool for selection, then that would be maternity discrimination. It is quite hard for women because obviously they haven't been there for a year unless they've got really good colleagues. We don't really find many women doing keeping in touch days, which I think is a bit of a shame actually, because I think particularly before they go back, if they have the childcare, I think that's really good for the employer and the employee, especially if you brought new software in and you want to do a bit more training on new systems. So, you know, again, we do use subject access requests a lot because, you know, they have to comply and give us information within 30 days, although a lot of them argue that it's complex and it's not. And unless there's a paper trail, you know, so, I mean, the potential legal issues, of course, are that the reason she's been dismissed is because of her maternity leave. One of the issues is with maternity leave is that if you do that in the protected period before she comes back, say there's, I don't know, 3 HR people and they just decide that they're going to make her redundant because she's on maternity leave. The law, it's the only example really, apart from reasonable adjustments, of positive discrimination, but she would get preference over her other colleagues for, say, if there's only one job that remained. And that was done to protect, you know, women on maternity leave. But there could be a genuine redundancy situation where they haven't eroded the role, but there clearly has been a downturn in that work, in which case you really would expect not to just give her a settlement agreement, but you would actually go through a fair redundancy that included, you know, this is why your job's redundant. this is, 2 or 3 consultation meetings, so that everything's very transparent. And again, time limits 3 months minus a day, but that's for putting in ACAS conciliation, and then we get these extensions. But yes, I mean, unfortunately, if you go to the pub with lots of women, and they're all sort of in their up to 70, I suppose. So many women have said, "Oh my goodness, that's happened to me." It's very common. It happened to me actually. So I took my law firm.
I'm sorry to hear that.
So, and that's why when we started the firm, we decided that actually this is why the pregnancy and maternity was really, really important to me, because it's just so common. And yeah, it's risen. I don't, why has it risen in the last 10 years? I think we've got a culture of presenteeism. I think women who take time off to have families are seen as being less committed. And of course, if someone wants your job, what great time to go and get it. Or, you don't want someone, they have problems with someone. It's just easy because they're just not there around to see what's going on. So, and I think training on this is really important about legal duties. Because I do think in some situations it isn't intended. But on the other hand, I mean, there can be situations where that leapfrogging, where the person on maternity leave, and actually there were performance issues, and actually it would mean keeping the least competent. That's where that becomes very, very annoying. But generally, it's not where someone's being made redundant and they're one of 5, all with the same job title. In most corporate environments, everyone has quite strange sort of job titles, and they're sort of standalone. But it may be that some people do a little bit of each, and then you put like 3 or 4 job titles into the pot. Much safer actually to wait until she's back at work and then do a redundancy when she's out of her protected period. So
I think what you said on those, I'm going to personally check in on those keeping in touch days.
Yeah, because it's fine if, obviously maternity leave is a really valuable time, and I think, a lot of women really enjoy it and actually get a break from work and want to be with their babies. But I think it is a really good thing to do if, particularly if they've got grandparents, they don't have to arrange, it's always difficult because you've got to organise a nursery place if you haven't got grandparents or family locally. But yes, I think that's a good thing. I think the way, really sorting out what leave and getting the holidays sorted out so that it's taken, which most women really appreciate actually, because it means that they get a larger amount. It's quite tough going from a full-time wage to just the statutory maternity pay. Amazingly, I see very, very few workplaces that enhance statutory maternity pay. It's very, very rare, even with really wealthy digital media businesses, and I think that's quite often because they're run by men. But if there is excess money, that is really helpful to families to have even if it's just another, rather than just 6 weeks, 3 months on full pay. But you see it rarely, except in local government and teaching and that sort of thing. Yeah, but if someone's great, you really want them to come back. And if they say they want to come back 3 days, it may be that if you have got some cover, you can create another job and then really get the equivalent of 6 days, and it works out. So, and of course, it's a short period really, but the more support that's given, the more likely you are to retain, which I think is really important at the moment. I think it is an applicant's market, and there is a real skill drain at the moment in terms of getting good people. So things like that are really good in terms of people's loyalty. And also, if you do give contractual maternity pay, you can then say that they would have, if they leave within a year, they'd have to repay it. So, it sort of protects the position and aids retention.